Hello friends, in the series on the income tax cases, today we will discuss the case of KISHORESINH, HEMANTSINH, CHUDASAMA versus Deputy Commissioner of Income Tax. This case has been reported in 103 ITR Tribunal at page number 391. The matter has been decided by Ahmedabad ITAT SMC bench and the date of the judgment is 29th March 2023. Nowadays, when the matters are being done in a faceless regime and the appeals are also faceless, so there is a lot of issues regarding that the assessee is not receiving the notices in the email, or even if the notices are received in the email, that notices does not relate to the professional who is handling the present matter. And sometimes the email are not updated at the portal, due to which the assessee is not able to receive the notices, due to which a lot of demand is being created by the department, so the assessee ultimately suffers. So the main theme of this case is that it is the duty of the assessing office of the assessee to first of all update his email ID, mobile number and address at the income tax portal, and also in the income tax returns being filed by him, that he should update his email ID, his mobile number and present address where he is residing, so that if any communication is done by the department, that is received by the assessee and due compliance can be done by the assessee on time. In this case, the addition was made of near about 22 lakh for the cash deposited by the assessee during the demonetisation period. When the notice was issued to the assessee under section 142 subsection 1, only one reply was being filed by the assessee, and in that reply also a lot of complexity was there. It was the point of the assessee that I received near about 24 lakh compensation for the land acquisition. I withdrew that cash to purchase some other property. I was not able to locate the property, that is why the assessee deposited the cash into the bank. Then again assessee withdrew this cash, and when the demonetization took place, the assessee once again deposited the cash. But the assessing officer was not convinced with the explanation, and the assessee didn't comply any other notice which is being sent by the assessing officer, because it was the plea of the assessee that the tax practitioner who was handling the income tax assessment proceedings did not cooperate with the assessee and didn't take the matter properly before the assessing authority. When the appeal was pending before the CIT appeal, the notices were being sent to an email which was related to one of the assessee's friends, and it was the plea of the assessee that the professional who was handling the matter of the CIT appeal didn't get the email about the hearing of the CIT appeal. That is why the order was passed against the assessee. When this matter was before the ITAT, it was the plea of the assessee that in a peculiar case the assessee has not been heard for any reason at the time of the assessment proceedings and at the time of the CIT appeal. So once more opportunity should be given to the assessee. The ITAT heard the matter and the ITAT remanded the matter back to the assessing officer, and it was the point of the ITAT that in this case at the assessment proceedings the tax practitioner of the assessee did not presented the matter before the assessing authority, and at the CIT appeal level the professional who was handling the matter was not aware of the notices sent from the CIT appeal. So it is a fair case where the assessee should be given one more chance. Friends, although in this case the matter has been remanded, but it is my suggestion that this type of situation should not be created, or the circumstances should be handled in such a way that all the notices are being complied with in due time, because nowadays whenever the additions are made, especially in the case of cash deposits, a huge demand creates, and whenever the matter is being remanded, it creates and it lengthens the period of litigation for the assessee. At the end of this video, once again, I am repeating the name of the case. The name of the case is KISHORESINH, HEMANTSINH, CHUDASAMA versus Deputy Commissioner of Income Tax, and this case has been reported in 103 ITR Tribunal at page number 391. The matter has been decided by Ahmedabad ITAT SMC bench, and the date of the judgment is 29th March 2023. Thank you, friends.